On the record. My name is Rebecca Tepper. I'm the Secretary of the Executive Office of Energy
Meu nome
and
é Rebecca
Environmental Affairs.
Tepper, sou a secretária da Ordem Executiva de Energia.
Thank you.
Okay. And the chair of the Energy Facility Siting Board. Before we get started, I'll ask the interpreters to provide instructions on using the interpretation services being provided today.
Thank you very much. We are providing American Sign Language interpretation using Zoom. Our ASL interpreter is visible on the screen in the hearing room and remotely on Zoom. At this moment, the Portuguese interpreter will begin reading the instructions in Portuguese.
Estamos oferecendo serviços de interpretação para esta reunião em espanhol, português, chinês, vietnamita e crioulo haitiano, bem como em língua americana de sinais. Esteja você aqui ou pelo Zoom, terá acesso aos serviços de interpretação oferecidos hoje. Se você estiver aqui na sala, você pode acessar a interpretação usando um receptor e fone de ouvido. Se precisar de um receptor e fone de ouvido, dirija-se à mesa ao lado da sala para obter assistência. O canal 1 do receptor é espanhol, o canal 2 é português, o canal 3 é chinês, o canal 4 é vietnamita e o canal 5 é crioulo haitiano. Para quem está no Zoom, em instantes ativaremos a interpretação no Zoom. Você verá um botão com um ícone de um globo que diz Interpretação. Clique no globo e selecione seu idioma. Por exemplo, para ouvir a interpretação para o espanhol, selecione espanhol. Para falantes de inglês, selecione inglês.
We will continue with Spanish.
Buenos días. Ofrecemos servicios de interpretación para esta reunión en español, portugués, chino, mandarín y vietnamita y criollo haitiano, así como en lengua de señas americana. Tanto si se encuentra aquí en persona como si participa a través de Zoom, tendrá acceso a los servicios de interpretación que se ofrecen hoy. Si se encuentra en la sala, puede acceder al servicio de interpretación utilizando un receptor y unos audífonos. Si necesita un receptor y sus audífonos, acérquese a la mesa situada al lado de la sala para que le ayuden. El español es en el canal 1 del receptor, el portugués en el número 2, el mandarín en el número 3, el vietnamita en el número 4 y el criollo haitiano en el número 5. Para quienes estén en Zoom, en unos instantes activaremos la interpretación en Zoom. Verán un botón con el icono de un globo que dice interpretación. Haga clic en el globo y seleccione su idioma. Por ejemplo, para escuchar la interpretación en español, seleccione español. Si habla inglés, seleccione inglés. Gracias.
Thank you. Next, Mandarin Chinese.
我们为本次会议提供西班牙语、葡萄牙语、中文、普通话、越南语、海地奥利语以及美国手语的口译服务。无论你是在现场还是通过Zoom参加聚会，明天都可以使用这些口译服务。如果你在会议现场，你可以通过接收器和耳机来收听口译内容。如果你需要收听器和耳机，请前往会议室侧边的桌子寻求你接收器。频道如下：西班牙语为频道1，葡萄牙语为频道2，中文普通话频道3，越南语频道4，海地克里奥尔语频道5。如果你通过 Zoom 参加聚会，我们即将启用 Zoom 的口译功能。你将看到一个标有口译的地球图标按钮，请点击该图标，以选择你所需要的语言。例如，如果你希望收听西班牙语口译，请选择西班牙语。如果你是英语使用者，请选择英语。谢谢大家。Thank you.
Next, for Vietnamese.
Chúng tôi cung cấp dịch vụ phiên dịch cho cuộc họp này bằng tiếng Tây Ban Nha, tiếng Bồ Đào Nha, tiếng Trung, tiếng Việt và tiếng Haiti Creole, cũng như tiếng Anh và ngôn ngữ ký hiệu Mỹ. Dù các bạn ở tại chỗ khán phòng hay trên Zoom, bạn cũng có thể nghe được phiên dịch hôm nay. Nếu bạn ở đây trong khán phòng, bạn có thể truy cập phiên dịch bằng cách sử dụng bộ thu sóng và tai nghe. Nếu bạn cần bộ thu và tai nghe, xin vui lòng đến bàn ở bên cạnh phòng để được hỗ trợ. Trên bộ thu sóng, tiếng Tây Ban Nha là kênh 1, tiếng Bồ Đào Nha là kênh 2, tiếng Trung là kênh 3, tiếng Việt là kênh 4 và tiếng Haitian Creole là kênh 5. Đối với những ai tham gia trên Zoom thì ngay bây giờ chúng tôi sẽ kích hoạt chức năng phiên dịch. Bạn sẽ thấy nút bấm biểu tượng quả địa cầu có nội dung phiên dịch. Xin nhấp vào quả địa cầu và chọn ngôn ngữ của mình. Ví dụ, để nghe phiên dịch sang tiếng Tây Ban Nha, vui lòng chọn tiếng Tây Ban Nha. Và đối với người nói tiếng Anh, xin vui lòng chọn tiếng Anh. Vietnamese completed.
Next, Haitian Creole.
Bonjour tout le monde. Nous offrons service interprétation pour réunion ça en espagnol, portugais, chinois, vietnamien et créole haïtien ensemble avec langue américain. Qui tout présent dans la salle là ou soit sous Zoom ou a bien accès à service interprétation à bay jodi a. Si vous dans salle là, ou ka joindre accès à service interprétation lors utiliser un récepteur avec un casque. Si vous besoin un récepteur à casque, tant pis, allez sous table qui sous côté salle là pour assistance. Espagnol sous chaîne 1 sur récepteur, portugais sous chaîne 2, chinois sous chaîne 3, vietnamien sous chaîne 4 et puis créole haïtien sous chaîne 5. Pour moun qui sous Zoom, dans quelques moments, nous allons activer interprétation sous Zoom. Ou après yon icône globe qui dit interprétation, cliquez sur globe là et puis faites choix langue. Par exemple, pour tendre interprétation en espagnol, tant pis, choisis espagnol. Pour moun qui parle anglais, tant pis, choisis anglais. Haitian Creole completed. Thank you.
Zoom interpretation is now turned on, and headsets will work on their language channels if you're here in the hearing room. That takes care of the simultaneous oral interpretation instructions. We do have one additional interpretation feature to mention. That is closed captions. Zoom provides closed captions, and these can be translated into other languages. To use closed captions, press the Show Captions button at the bottom of your screen, then press the up arrow and select My Caption Language and the specific language you want for your captions. That concludes our interpretation instructions, Secretary Tepper.
Again, welcome everyone. This is a hybrid meeting of the Energy Facilities Siting Board taking place at the offices of the Department of Public Utilities, 1 South Station, Boston, and on Zoom. This hybrid meeting format is intended to allow everyone to see and hear all speakers, whether here or on Zoom. With me today are the other members of the Siting Board: James Van Nostrand, Chair of the Department of Public Utilities; Stacy Rubin, Commissioner of the Department of Public Utilities; Elizabeth Mahoney, Commissioner of the Department of Energy Resources; Bonnie Heipel, Commissioner of the Department of Environmental Protection; Doug Gutro, Director of the Permit Regulatory Office, and designee for Secretary Eric Paley of the Executive Office of Economic Development, and John Bonifiglio, public member. Additionally, Andy Green, Director of the Siting Board, is here with the board and will be serving as the Zoom meeting host. The meeting today concerns the Siting Board's role in implementing the 2024 Climate Act, signed into law by Governor Healy in November 2024. The 2024 Climate Act makes many changes in the way that clean energy facilities will be sited and permitted in Massachusetts. The Siting Board is required to promulgate regulations and guidance to implement these reforms by March 1, 2026. The regulations that result from this process will apply to projects filed with the Siting Board starting July 1, 2026. The purpose of today's meeting is for the Siting Board to consider and vote on the tentative decision issued by staff that would open a rulemaking proceeding to implement the provisions of the 2024 Climate Act and invite public comments. In brief, the rulemaking process described in the tentative decision includes: 1, revisions to 2 existing Siting Board regulations; 2, 4 new regulations; and 3, the repeal of 6 regulations. The tentative decision notes that the Siting Board plans to propose 1 additional regulation at a later date that will focus on cumulative impact analysis and the use of site suitability criteria, for Siting Board jurisdictional projects. Guidance documents pertaining to these topics are currently in development at the Executive Office of Energy and Environmental Affairs. The Siting Board will provide more information about the cumulative impact analysis proposal in coming weeks. and there will be opportunities to provide comments and suggestions on the draft regulations before they are issued for formal public comment. Siting Board staff are continuing to develop the guidance document for the consolidated permit applications for clean energy facilities reviewed by the board. 2 items of particular importance: baseline environmental health and safety standards and common conditions for consolidated permits issued by the board. The Siting Board staff are collaborating with DOER on developing these baseline standards and common conditions and expect to release a draft document in the next few weeks. Siting Board staff will provide more information on that today. The Siting Board's proposed rulemaking for the 2024 Climate Act reflects an important milestone for this legislative and regulatory effort. Over the past 2 years, many stakeholders, community organizations, industry representatives, state and local officials, and members of the public have been actively involved in the discussion on siting and permitting reform, and now the implementation of this landmark legislation. The Siting Board has conducted extensive outreach during the development of the proposed regulations. In April 2025, the Siting Board staff issued 4 straw proposals on key topics for the 2024 Climate Act. The Siting Board, along with EEA and its Office of Environmental Justice and Equity and the Department of Public Utilities, hosted a series of virtual and hybrid meetings in April and May 2025 to brief stakeholders, answer questions, and provide a forum for oral and written comments. Siting Board staff also conducted multiple interagency consultations and continued to meet with a variety of agencies and stakeholders to discuss the new siting program. At our recent board meeting on July 21, 2025, the Siting Board met to discuss an initial set of draft proposed regulations and listened to public comments. Subsequent to the board meeting, we have received written comments from utilities, developers, interested individuals, organizations, and others. The written comments were posted on the 2024 Climate Act Regulations meeting webpage. As a result of the input from the Siting Board members and comments from agencies and the public, Siting Board staff further refined the draft proposed regulations, which we are considering today. If the board so votes, the proposed regulations will be filed with the Secretary of State and will begin a formal public comment process. For today's meeting, staff will provide a briefing on the draft regulations and guidance and update the board on comments made and changes to the regulations since our last meeting. The board will then ask questions and provide feedback. We will also have time today to listen to public comments and questions regarding the proposed draft regulations. We will deliberate and then vote on the tentative decision. As a reminder, we are on a tight schedule to develop these regulations in time to meet statutory deadlines. I realize that both the tentative decision and the draft regulations were posted and distributed late last week. Please keep in mind that a vote to proceed with the rulemaking begins the public comment period and process with additional hearings that will take place in locations around the state. To set expectations for today's meeting, I note that all materials presented by staff today will be posted online today and will be translated into additional languages and posted as soon as possible. If approved by the board, the proposed regulations will be filed with the Secretary of State next week for publication in the Massachusetts Register on September 26. This begins the formal review process required by law. The review process will include public hearings, technical sessions, and working sessions to continue to refine and improve the proposed regulations. A formal comment period will close on November 7th. The Siting Board will meet again in January to vote on the revised regulation package and send on for final review. A final board vote to promulgate the regulations and issue a decision will take place in February 2026. The regulations will be submitted to the Secretary of State and published in the Massachusetts Register prior to March 1st. The Siting Board provided notice of today's meeting to the Commission on Energy Infrastructure Siting and Permitting, a broad group of stakeholders and member organizations, the Siting Practitioners Advisory Group, and an interagency task force for siting and permitting. The notice was also posted on the Siting Board's website and provided under the Massachusetts Open Meeting Law requirements. The notice was translated into the languages mentioned earlier. Before we begin the substance of the meeting, I will provide some important information about how we will be conducting the meeting today. First, the agenda for today's meeting. We will take up the sections of the proposed regulations as presented by EFSB staff. After staff presentations on each topic, the board will ask questions and make comments. We will then hear public comments on the specific topics presented in that session. We will take comments first from members of the Commission on Energy Infrastructure Siting and Permitting, SPAG, the Interagency Task Force, and then the public. Following the staff presentations and discussion, the board will begin deliberation on the tentative decision, consider possible amendments, if any, and vote on whether to adopt the tentative decision. We'll break around 12:50 for lunch and resume at 1:50. The siting board is conducting today's meeting both in person and remotely using Zoom. This meeting is being recorded and will be available on the siting board's YouTube channel. For our remote attendees, if you are having any difficulty with Zoom, please call or text 857-200-0065 for assistance at any time. A stenographer is present today to transcribe everything said to make an official record of the meeting. Everyone should speak slowly and clearly and allow the prior speaker to finish before you begin speaking. This will help ensure an accurate transcript. We're now ready to begin the substantive portion of this meeting. As I mentioned, the sole item on our agenda today is to hear from Siting Board staff about the Siting Board's proposed regulations to implement the 2024 Climate Act. When we take public comments, I will ask commenters to limit themselves to 3 minutes so that we can hear from as many people as possible as time permits. We will call public commenters in order in which they have signed up. For those on Zoom, please unmute your microphone, turn on your camera if you like, state and spell your last name for the stenographer. So our first topic today is a staff presentation of the tentative decision, preview of subsequent presentations, and our presenter, Ms. Evans.
Can you hear me? Thank you. So before I begin with a presentation of the tentative decision, my name is Joan Foster Evans. I'm the general counsel of this item. Excuse me. I'm going to just touch base.
Ms. Evans, I'm going to give everybody this instruction, but it's hard to remember, but try to keep the microphone up to your mouth like a rock star. And it's difficult to do, but just try so that everybody can hear and Zoom can hear.
It's amazing that the first speaker has to be reminded of this. Thank you. I'm going to first start with a very short overview of the provisions of the 2024 Climate Act for those folks who maybe were unable to attend any of the stakeholder meetings or the board's meeting in July. And so in the 2024 Climate Act, the Climate Act created a new category of infrastructure, which the Climate Act called Clean Energy Infrastructure Facilities. And the Climate Act treated these types of facilities differently than the types of facilities that the board has normally reviewed and voted on. The Climate Act also expands the siting board's jurisdiction to include large energy, clean energy infrastructure facilities and including storage facilities. So the Climate Act created two different consolidated permit programs, a program for large CEIF, which is focused around the siting board, and then for small CEIF for a local consolidated permit to be issued by municipalities. The Department of Energy Resources developing the regulations for the small program. An important part of the 2024 Climate Act is that it establishes deadlines for deciding on an application and gives those deadlines teeth. It provides that a constructive approval will issue if the siting board does not meet its deadlines, and that type of approval also applies for local municipalities. The Climate Act establishes a number of new requirements for CEIF applications. Two that I'm highlighting here, including an extensive pre-filing consultation and public outreach requirements. And those requirements also apply to the existing legacy facilities and cumulative impact analysis requirements, and those regulations will be proposed shortly. The Climate Act expands the siting board membership, establishes a new mandate, changes our scope of review and required findings. It significantly changes the way that the board works. And finally, it moves certain Department of Public Utilities siting jurisdiction to the board. Next slide, please. So as Secretary Tepper said in her opening remarks, we have a number of new and revised chapters that the siting board is proposing to repeal 6 chapters that the siting board does not use right now. In addition to the proposed package that you have before us, the siting board staff will be issuing the cumulative impact analysis proposed regulations shortly after some more public process on those proposed regulations. The Department of Energy Resources will be shortly issuing its consolidated local permit regulations, and the Department of Public Utilities has 2 sets of regulations. The Intervenor Support Grant Program, which is also ready to issue very shortly, and application fees which will be a little bit after these other regulations are issued. Next slide, please. And we've talked, I think, briefly about the important dates. I think the thing to emphasize is that while we've had an extensive informal process so far, this is the beginning of the formal process. And there'll be more input and opportunities for both written and oral comments on the packages that are presented today. So next, I would like to go ahead and present the tentative decision. So on September 4th, 2025, the siting board issued its tentative decision opening the rulemaking for new and revised regulations to implement the 2024 Climate Act. The tentative decision includes proposed regulations to be filed with the Secretary of State this Friday and to initiate the formal rulemaking and comment period. These proposed rules are the culmination of months of internal meetings with multiple agencies and the Siting and Permitting Commission, as well as numerous meetings with stakeholders from industry, community groups, environmental groups, members of the public, and others. We coordinated extensively with EEA and other EEA agencies. The proposed regulations reflect the thinking and input of many people. And this input allowed staff to draft and refine this package of regulations and guidance to keep us on track to promulgate these regulations by the statutory deadline of March 1st, 2026. We appreciate the efforts of many people, and many of them in this room. The proposed regulations, together with the proposed regulations from DWR and DPU, as well as guidance documents from EEA, are integrated pieces of a program to fundamentally change the siting and permitting of CEIF in Massachusetts. And some of the new provisions will apply to the siting board's legacy facilities, those facilities not included in the CEIF definition. The proposed regulations also include improvements in the way the board conducts its business in order to efficiently and effectively review and decide siting applications. As we have discussed, the 2024 Act creates a consolidated permit process by which the siting board will issue all necessary local, regional, and state permits and approvals for large, clean energy infrastructure facilities and, in certain circumstances, small clean energy infrastructure facilities. The Climate Act created new categories of facilities, new roles for state, regional, and local agencies and various stakeholders, and new procedural mechanisms. The Climate Act establishes mandatory deadlines that will apply if the siting board fails to issue a decision by the application deadline. The Act also creates significant pre-filing consultation and community engagement requirements in order to inform agencies and the community about upcoming projects and facilitate dialogue to provide feedback on the priorities in the communities. Staff will also be proposing cumulative impact analysis regulations soon, and these regulations will recognize existing burdens in communities and assess potential added impacts from proposed projects. In order to accomplish the Act's goals, staff organized the Consolidated Permit Program around well-defined application requirements and associated guidance. The application requirements make it clear what is expected of applicants and make this information transparent to stakeholders and agencies. The application regulations also standardize requirements, making the review process more timely. The application requirements also define how a consolidated permit proceeding will be conducted, so all participants are aware of the manner in which a record will be assembled and their roles in the process. We proposed revisions to the board's procedural roles and conduct of board business in order to support the whole consolidated permit program. In order to ensure that applicants are ready for the consolidated permit process, the proposed regulations include explicit pre-filing requirements. Applicants must consult with relevant agencies to identify which permits are needed and provide drafts of those permits. Indeed, the consolidated permit process provided in the proposed regulations rely on the expertise of permitting agencies in the pre-filing stage, during the consolidated permit proceeding, and in the enforcement of permit conditions. We will rely on Mass DEP for its expertise for instance, in wetlands laws, and the Department of Fish and Game for expertise related to endangered species protection. I would like now to say a brief word about the coordination between the Siting Board Consolidated Permit Program and the Consolidated Local Permit regulations that DOER is developing. Siting Board staff have been working closely with DOER to ensure that the two permitting sets of requirements are consistent for developers, for agencies, and for the local community. This includes developing baseline standards and common conditions and coordinating on the development of those. For the local portion of a consolidated permit, the Siting Board will rely on the procedures and information required by DOER and integrate that information into our proceedings. Under the Act, there is an opportunity to ask, in addition, under the Act, there is an opportunity to ask the Siting Board to take a look at local permitting decisions, making this coordination even more important. This board meeting and these proposed regulations and guidance are the beginning of a formal comment process. The tentative decision identifies key dates for that public comment process, and we will be issuing a formal notice of the public process this week. The Siting Board staff welcome continued comments and ideas from stakeholders and the public. Siting Board staff will consider the comments, revise the proposed regulations, and present the proposed final regulations approximately at the beginning of next year. The rest of staff's presentations will discuss input we received since the last board meeting and how we address that input in our current proposed regulations. I am glad to take questions now, or we can entertain staff questions as staff present the additional or individual proposed regulations sections. Thank you.
Does anybody have any questions for Ms. Evans? I guess before we start, I would like to thank you and your whole team for putting together a very comprehensive set of regulations that you have a small staff, You worked really hard, and there was a very tight timeline in getting them done. And just stepping back for a moment, I just want to note for the board what a big day this is for the Energy Facility Siting Board. For people who have been working in this field for a long time, we know that we have been trying to do this kind of work to have expedited permitting for, I think, maybe 20 years. And we're now doing it. And thanks to you all and all of your work, I'm really proud to be saying that we are doing it now. And I'm really looking forward to see how this all plays out. So thank you to all of you on the staff for all the very hard work that you have done to get us to the point we are today. So let's do your first presentation.
You're going to hear from me again.
Okay, let's hear from you.
Could we go to the procedural regulations slide? Thank you. We've already talked about this a little bit in the previous presentation, but what we're going to talk about here is revisions to the existing procedural regulations that define how an adjudication at the board works. Also, the regulations that define the board business and how that's conducted. We're also going to talk about a new regulation for de novo adjudications of local consolidated permit decisions. And I'll start with that one. Okay. So, I'm sorry, just one second, please. Let's jump over to the slide on adjudicatory proceedings if we can. I don't need to go through, I think, all of that. You could just go forward to the slide right there. Thank you very much. So we talked a lot in our last board meeting about the adjudicatory procedural regulations, and I want to highlight a few areas where we heard from stakeholders and commenters that we needed to revise or update the regulations that we presented this summer. Again, these are existing regulations that have been revised to reflect the new processes. We included a provision on decommissioning plans in the proposed regulations. This is something new. It was not required by the act, but we heard from a number of stakeholders that the board should have some kind of decommissioning regulations. And so we did include those in the draft regulations from the summer. We heard that the decommissioning plans should be required on a case-by-case basis. There may be situations where decommissioning is not needed. I think in oftentimes in relation to utility projects that stay for a very, very long time once they are built. And we did include a provision on those decommissioning regulations that they would be required on a case-by-case basis. We did want to reflect that input. We received comments on the segmentation procedure that we had included in the regulations. And we changed the kind of the forward-looking piece of the segmentation regulations from 5 years to 3 in response to those comments. We heard a comment about newspaper notice, and I think there's a lot of multiple feelings about newspaper notice, as many people do not read the regular newspaper right now. We felt that the notice requirements should be cumulative of multiple channels as opposed to deleting the existing newspaper channel. So we did leave the newspaper notice requirement in the regulations, but recognize that there'll be many other channels of notification also that will happen with proceedings. And we had a question about requiring certain documents to be posted in the pre-filing stage. We did include a requirement that would require, if an applicant got a waiver of pre-filing requirements, that waiver would be a public document, so that and whatever disposition that waiver, so that the public would know if there were certain things that the applicant did not need to do. some other smaller key updates. We did transition finally from our regulations requiring hard copies of everything. And so we did recognize that filing should come in electronically, but we did require or give the presiding officer options to require hard copies where necessary. So that was a small change. And we did reflect the fact that the cost of AV equipment and language interpretation we will request that the applicant provide the cost of that. Any question on these procedural regs before I go into board business comments?
I just had it. Oh, go ahead. You go first.
Thank you, Stacy Rubin. I just want to thank the staff very much for the hard work and to make 2 comments. Just on the segmentation piece, I very much agree with the recommendation to retain the 5-year period when we're talking about segmentation. I think it also makes sense to be consistent with MIPA regulations here, even though MIPA is no longer applying for these facilities. And just wanted to comment on the support to retain the newspaper notice as well as a broader set of notice for people so that they can be aware that these projects are happening. I'll just say I'm aware that there are certain communities where people still do look through the newspaper, and that is their way of finding out information. And then some people rely on radio or social media. So I think it's great that the regulations cover a broad way of people to find out about the project. So thank you, and I'm very supportive of the language in 1.
Thank you for pointing out the segmentation piece that we did retain the 5 years. Thank you.
I just had a question on the newspaper. How much does it cost now for somebody to do a notice in like the Globe? We know?
I do not know how much that cost is. I think some of the members, representatives of the companies might be able to give a number to that. Or
Probably the people back at the office will know the answer to that question.
I don't know.
Okay.
I'll just add that part of the concern that we've heard with newspaper notice is that some more local papers in the Globe are switching to even longer of a cadence between issues. So if a community does rely on what used to be a weekly paper, it may now be bi-weekly. And in particular, when we're attempting to expedite the process, we've heard concerns at DEP in other contexts about just adding delay because of the back timing of those more local papers.
That sometimes also applies with other language papers. We have to back up and make sure that we hit the publication date on those also, which we do now.
Commissioner?
I just have one example. It costs DOER $1,000 to publish for our regulations. So to the extent that translates to projects, it's about $1,000.
I'll go on to 2.0. More fascinating procedural regulations. So again, 2.0, current regulations. Siting board staff proposed a number of changes to those regulations to reflect the new board process and also to make some corrections and updates to those regulations. So the new regulations broaden the siting board's scope of review. Siting board staff had included a provision to recognize that the board needs to consider efforts to discuss with the community benefit plans or community benefit agreements. Those 2 plans or agreements are not required, but there's a significant guidance coming from OEJE on those types of agreements. And the regulations right now recognize that the board should consider what negotiations go on for those agreements. And another issue that will hopefully be implemented maybe even before March 1st is the idea that we do establish standing monthly siting board meetings to process siting board work on a more efficient basis. Right now, we set up siting board meetings on an as-needed basis. It's a fair amount of coordination to get on everyone's calendars, and the suggestion was made for us to schedule those on a regular basis, and when we think that's a good suggestion. And another update to the 2.0 regulations is just a recognition of the permitting dashboard required by the Act, and that permitting dashboard provides that we can add, delete, and change the information on the dashboard as meets the needs of the information that we have. Does anyone have any questions on the Siting Board 2.0 regulations?
I have a question on the broadening of the scope of review. What is the sort of substantive implication for including the community benefits agreement rather than having the applicant considering the applicant's efforts?
But right now, I believe that the regulations do say that the Siting Board will consider the applicant's efforts to avoid, minimize, and mitigate impacts, and also their efforts to address a CBP or a CBA.
So I'm trying to understand what is the consequence of including that versus not including it?
The intent was to recognize, use this as another vehicle to recognize the applicant's engagement with the local community.
But does the scope of review simply mean, does it have any weight to it? In other words, like, is this something that is required to consider in making a determination as to whether to approve the project? Or is this just, as part of your application, we're interested in hearing what you have done with respect to community benefits agreements?
I think the weight is what weight the board puts on that factor, but we wanted to make sure that that factor was considered by the board in its deliberations because it was so important. But there was no specific weight given to it in the regulations. I think that's a matter of the Siting Board's discretion.
And there's no
its weight.
There's no requirement to have a community benefits agreement.
There is no requirement to have a community benefits, and there's no requirement that the board determine whether or not there needs to be a community benefit agreement. It just is a factor for the board to weigh in its consideration of all of the factors involving the application. I'm not sure I'm answering your question.
Could I jump in to add one additional point, which is that there is guidance on community benefit plans and community benefit agreements that's still being crafted, led by the Office of Environmental Justice and Equity. And that will presumably have a variety of different recommendations that would bear on how the board concludes rulemakings and how this tie in with the community benefit plan issue is addressed in our regulations. So we haven't gotten the final language yet from that guidance document, and we will have to evaluate that, and that may have some degree of influence over how sort of hardwired, if you will, the community benefit planning process is into our procedural regulations.
I'm trying to just understand the basis for the change here. That's helpful to know in terms of the details of what an agreement might look like. Was there a concern that the initial language suggested that a community benefits agreement might be required? And the change was made to clarify that a community benefits agreement could be an example of something that was used to avoid, minimize, or mitigate impacts?
I think that the staff does want to make sure that that is clear, that it's not required, but it is a factor to be considered by the board.
Okay.
I don't think it was what you're saying. I don't think it was to demonstrate that it isn't required. I think it's saying we want to know what you did in terms of, did you talk to the town? What conversations did you have with the town regarding a potential community benefits agreement? So to me, that kind of implies, well, some negative implication for sort of not having a community benefits agreement. And, you know, there are pros and cons on both sides of that, right? There's some project that's just not going to be the kind of project that you would have a community benefits agreement for. And then presumably that project would say that. You know, we don't believe that a community benefits agreement was appropriate in this case. We spoke to the town about that, and that's what we're going to say. And I guess my question was kind of like, well, what does that mean?
Right.
Like, and I think what I'm hearing is it doesn't mean anything if the board says, well, that's, you know, okay, that's what they did. But I too am having a bit of a confusion about how it plays out in real life. Go ahead, Mr. Guttrow.
So quick question along the same lines, the community benefit agreement. So this board doesn't approve or consent. They're aware that there's a community benefit agreement between two parties, correct?
The board does not approve the community benefits agreement. It could be a piece of evidence in a proceeding to talk about how the applicant engaged with the local community and local community groups, but there's no
I understand.
approval by the board, and there's no enforcement by the board of any kind of community benefit.
And so this language is just to be transparent, to allow us to understand the applicant's efforts to try and negotiate a community benefit agreement.
I'd say even more broadly, the applicant's efforts vis-a-vis the local community and local community groups. It's a piece of evidence going to the question of what the applicant is doing with the group. It's not, the community benefit agreements, again, it's not required. Therefore, the board can take that information and possibly find out that, hey, this particular one was not this particular project was not appropriate for CBA. But that is a piece of evidence to be considered by the board.
And final question, if let's say there's no CBA because they couldn't reach an agreement, and this board feels that some mitigation is of value, does it have the power to condition approval with mitigation or no?
It always has the authority to approve with mitigation. I don't think the board would require a CBA. I think that there would be problematic. That's problematic, but the board can require certain types of mitigation. Absolutely, the board will be requiring certain types of mitigation for every project.
Thank you.
Just a follow-up question. This is Stacy Rubin. Can you just explain the distinction between a community benefits plan and a community benefits agreement? And if there is an agreement, what the timing might be vis-a-vis the board decision?
So my understanding, again, is as Mr. Green pointed out, this is still a little bit in development right now. My understanding is a community benefit plan is a before a plan by a developer on what it's going to do with the community. A community benefits agreement is actual, like a contract. It probably appears later on in the process, possibly even after a board decision. The community benefit agreement's an enforceable agreement. It's a contract, but not enforceable by the board. It's enforceable otherwise. It's an agreement where the parties have reached, you know, a conclusion to their discussions.
Thank you very much.
Yes.
Did you ever give any thought as to what would happen if a community plan agreement was consummated, but it wasn't followed by the applicant?
We did discuss that, but the main point, the way host community agreements are currently reflected in board's practice, is that the parties would have to go and use whatever provisions that were in the agreement to deal with non-compliance, or have to go to court if they had a non-compliance issue that they didn't have provisions in the agreement to address. but they do not come to the board. It's a private agreement. In part, we've seen with host community agreements, sometimes the agreements include things that are well outside of the board's jurisdiction, right? We see, payments for a fire truck or something like that, where a company might agree to give payments to a community for certain items that are clearly outside of the board's jurisdiction. The board does not enforce those agreements. Either the agreement has provisions within the agreement as to what happens in a case where there's non-compliance, or the parties would go to whatever the normal venue is for a contract dispute.
Mhm. And the impact on the permit process itself?
The permit process would run on its own. This would be outside of the actual permit process.
Okay.
Because we would not say in a decision that the parties must comply with the CBA, because that would make the board the enforcement arm, and that is not an appropriate enforcement arm.
Thank you.
Any other questions? Yes, Ms. Heupel. Commissioner Mahin?
Sorry, I'm just coming back to the discussion we were having about this expanded scope of review and looking at the particular language, which I don't know where I'm just going to concede, I don't know where I land on this yet, but the language starts out with scope of review. The board shall review, and it has in there that the actual, what the board's going to review. And then it has another paragraph that says, the board shall also consider the applicant's reasonable efforts, which gets us into this discussion we were just having. And the question that I think you were starting with, Secretary, is what onus is on the board to review these efforts? And I guess where I'm getting stuck is, based on some of the answers, the board shall also consider. And is shall the right word in there, given that what you're saying is that what Ms. Evans and Mr. Green just said, that there's going to be, it's up to the board to decide the weight. The word shall in there seems very heavy-handed if we're just considering the weight. I think it may be better to say the board may also consider. That gives us more flexibility. Just given the discussion we had right there. But again, I conceded at the start. I wasn't sure where I was landing, but that's where I'm teetering.
We were hoping the term consider included that flexibility, because that allows the board to give whatever weight the board decides to give to that particular consideration. But you're right, the word shall is more heavy-handed than may.
Commissioner Heupel, did you have a question? No. Okay. So in terms of sort of thinking about if we wanted to make some changes, how would that work today?
So these regulations have already been approved in the interagency process by ANF. It's easy to make changes to the tentative decision. We'll issue it as a final decision later this week. Depending on the nature of the any proposed changes to the regulations themselves, we would have to check and see what the process is to go back up through the governor's office and ANF to make those changes. One alternative, of course, is to reflect language in the TD and then make the changes in the final version. That is something that's easy. I am not sure, with the amount of time between now and Friday, how many changes we could make up through ANF and the governor's office. The easier thing would be to do is to reflect this discussion in the TD, which becomes a final decision this week.
And then the final regulations, presumably you would make a change in the final regulations that would come back and be approved here.
We can do that, yes.
I just don't want us to be in the final regulations doing the same thing over again that we're doing now. See what I'm saying?
Absolutely. Would the proposed change right now be to change that word from shall to may?
Are you proposing that?
That would be my proposal if I were to make it.
We will have a deliberation later on in the meeting where we could formally propose that change. We can put it in the decision and see if we can get the sign off. I just can't speak directly for A&F and the governor's office in the next 4 days.
I mean, I think what we want to do is do this the easiest way that we can, and still have the same result. I mean, my personal view is that if the board votes on a change to the regulations, then the board votes on the change to the regulations, and that's the way it is. But if that's going to cause problems and we're worried about that, then we should do it a different way, which as you talk about, we'll make a note in the tentative decision that the board has voted on that change and that it will be made in the final decision, in the final regs.
Yeah, we can do it. Again, I cannot speak on behalf of the governor's office and A&F on any changes that the board might try to make today, but we can attempt to do that, but definitely put the language in the.
I'm not saying, what I'm saying is I hear you on that. And so I'm not proposing that we do it. I'm proposing that we do it the other way that you recommended.
We can do that. We'll just need to do it during the deliberation portions. We'll get a formal motion.
Okay, can we ask the staff to keep track of the things that, because it's going to be a long day, keep track of the things that we're talking about, so that we don't have to do this all over again later on.
Yes.
Any other questions? Okay.
Thank you. So we're going to next do the regulations at 14, which is the de novo adjudication. I'm going to ask that Daniel, that you've heard enough from me, and that Daniel Kelleher, one of our presiding officers, come up and present the 14.0 and the 17 regulations. Thank you.
Thank you. Good morning. The 14 regulations, the title of them is De Novo Adjudications of Consolidated Local Permit Applications. And just to remind the board, this concerns the de novo adjudications that would be conducted by the Director of Consolidated Local Permit Applications. There are basically two ways that these adjudications would come before the Director. One is that the local government would issue a decision either approving or denying a project, and then either the applicant for that project could ask the Director to conduct a de novo adjudication, or another interested party that's substantially and specifically affected by the local government's decision could ask the Director to conduct a de novo adjudication. The second method for a de novo adjudication coming to the Director is if the local government asks, basically says, we don't have the time or the resources to conduct our review, we're going to ask the Director to conduct it instead. So that's the background. If we could go to the next slide, please. So on the left, we have comment themes. We've highlighted 4 of the themes, and then the regulation update or response. I'll just say that in general, most of the updates that have been made since July have been in the way of clarifying the existing regulation, the existing draft. There have been very few substantive changes. The first comment theme is to clarify overlaps and differences between the Department of Energy Resources and the Siting Board regulations. And the staff is working closely, the upper levels of the staff is working closely with the DOER to ensure consistency and clarity. The second row is essentially one example of clarifications that have taken place. The regulations are a little confusing because in order for somebody to request a de novo adjudication, they're essentially petitioning the director for that. But they've also earlier perhaps applied for the local, for the consolidated local permit application. So we've just undertaken to be clear that if we're talking about a petitioner, we're talking about they're petitioning to ask the director to conduct a de novo adjudication. For number 3, it's when a local government requests a de novo review, the local government should be responsible for transferring the administrative record. In general, we've just tried to be clear about whose responsibility it is to provide the director with the information that the director needs to conduct the de novo adjudication. So the response is that the draft regulations provide that the local government is responsible for providing a statement, essentially saying we don't have the resources to conduct our review, and then the applicant has responsibilities of providing the director with the underlying application. The last row here does highlight a potential substantive change. We did receive comments that the board doesn't have the authority to, the board doesn't have the authority to grant the director 12 months if the de novo adjudication ends up being presented by the local government. We did not make that requested change. The local government has 12 months to conduct its review, and the 6-month requirement really applies to a de novo review that arises either from a request from the petitioner or other party specifically affected. It doesn't specifically apply to a request by a local government. And also, it's just unrealistic to expect that the director would act in a 6-month time frame when the underlying local government would have had 12 months. And unlike a decision that the local government had made, if the local government makes this request, the local government will not have done its own initial review. So the director will essentially be starting from scratch. So 12 months is a reasonable time frame. If we could go to the next slide, please. So here are 2 specific updates. So oftentimes it's very useful to say what these regulations do not do. And the first line is an example of that, just to make clear for a practitioner that, wait. Now I got a little confused there. Yeah, this was just a necessary change that we provided, that a final decision includes not only the granting of a consolidated local permit, but also the denial of one. That was a very necessary change. The next one has to do with just making sure that we're clear about who is responsible for providing the director with the information the director needs to make a decision. Next slide. Oh, yes. Let's do one set of regulations at a time. Are there any questions related to the de novo adjudications regulation? And I'm a little surprised by this slide. I just want to make sure it's the one that was intended, because it's not the one I was expecting. Oh, there we are. Okay. All right, so I will move on to the section 17 regulations, which relate to the constructive approvals. Again, these regulations have to do with the deadline that is required. The board has a certain deadline by which it is supposed to issue, make final decisions. If those deadlines aren't met, the statute provides that the project will be constructively approved. These regulations describe the process for that constructive approval, in other words, automatic approval. This first line, there was concern about the potential for applicants to procedurally stall an application with the intent of receiving constructive approval. That was brought up at the last board meeting. We did make substantive changes in that regard. Those substantive changes appear not in this particular set of regulations, but in the 13 regulations regarding the consolidated permit procedures. And just in general, it's just making clear that the board/presiding officer has authority to enforce deadlines. It requires that if a party wishes not to comply with the deadline, it needs to get permission to change that. And then if it does not comply with the deadlines and doesn't have permission, then there is a procedure that requires some warning. But eventually, if there's a repeated delay, a repeated failure to comply with the deadlines, then the presiding officer has authority to impose penalties, including, I believe, dismissal. Correct, Connor? He'll speak about it at his own time. So the next line, further streamline the constructive approval process. I mean, certainly it's the intent to adjudicate as many of the applications as possible. We're not trying to utilize the constructive approval process if possible. I think the regulations as drafted do provide a streamlined process that is not very time consuming. It's just, it includes process to ensure that the parties are aware of what would happen if a final decision doesn't issue, and to prepare the parties for that possibility. The last row, constructive approval should not include project-specific conditions subject to citing board deliberation. That theme was already present in advance of the last meeting. I would just say that these regulations clarify what the source of the conditions are that end up being incorporated into the constructive approval permit. They are all common conditions. They have three sources. One is going to be the board's common conditions. Another one is going to be, what do we call the other agencies? The permitting agencies? The other state level agencies that are permitting agencies. And then there will be, the Department of Energy Resources common conditions as well. So I think just conceptually, it's fairly simple that it's all common conditions that are being included as conditions. If we can go to the next slide. All right, so I did start to speak to this earlier, but this is an example of just specifying what the regulations do not apply to. So these constructive approval regulations do not apply to the de novo adjudications. That's sometimes very helpful to a practitioner if you see a line and then you see, okay, it doesn't apply, I can move on. The next bullet point has to do with the common conditions. So I spoke about that there are these three different sources for the common conditions. So in general and in summary, there have not been significant substantive changes outside of the ones I highlighted, and there has been a lot of work towards improving clarity and making sure the regulations are consistent with other regulations. Are there any questions on these constructive approval regulations?
Yes, we're going to take questions right coming up next. Okay. So are there any other board questions? Any board questions on 17? Okay. So we are now going to move on to comments. So the comments that we're going to take right now are on 980 CMR 1, 980 CMR 2, 980 CMR 14, and 980 CMR 17. So can we have, do we have any comments from the commission or from SPAG or any other comments that people want to make from those groups? Yes. That's Steve Long. Sure.
Great, thank you. I just want to echo the thank you to the staff. This is quite a lift that you have all done getting these regulations ready, so thank you very much. And my question is on 17, on the constructive approval, and I didn't hear mention of site suitability and wondering if that is included.
Am I on? Yes.
You are.
Thank you. The site suitability piece would be in with the 15.00 regulations that we will be proposing shortly. So in addition, DOER, of course, has site suitability requirements in their draft regulations, which are coming out, I believe, very shortly. Yes. So the site suitability will show up, but it will show up in 15.00 in the new proposed regulation that's coming out shortly. Thank you. That are coming out shortly.
And is there a link between 15 and 17 for the constructive approval? I'm trying to remember what 15 is. I'm sorry.
I'm very sorry. 15 is for cumulative impact analysis and application of site suitability standards that EEA is working on that you're very well aware of. And are you asking? So 17 has conditions, we will have standard conditions attached to it. And you're asking whether or not those standard conditions will reflect site suitability?
Yes.
I believe that they will, but they have not been completed yet. So I can't speak to any more detail on that right now. Maybe Mr. Green can answer that question because he is working on those.
You are correct, General Counsel. So the baseline standards will include references to a variety of different existing regulatory requirements that span state government. It will include elements of the guidance documents, I should say, that touch on this issue, as well as actually reflected in the application itself.
Thank you. And I'm assuming that includes, so a second part of the question, the avoid, minimize, mitigate hierarchy. The second part of the question, there is the mitigation hierarchy that requires avoiding, minimizing, and mitigating. And I'm wondering where that ties into 17.
The avoid, minimize, mitigate is a sort of bedrock requirement that cuts across a lot of elements of our regulatory program. So it actually touches in a lot of different places, including baseline standards, conditions that will reference the hierarchy, as well as the application contents itself and how they're to be developed.
But just to be clear, so the constructive approval is granted when the board has not completed with the review within the 12-month period, correct?
12 in the case of a small clean energy facility, 15 months for a large clean energy facility.
So in that situation, there will not be any project-specific conditions.
That is correct. And what comes into play in the situation where we have a constructive approval is that we essentially default to the common conditions, which are being developed as part of the 13.0 regulation that we'll be hearing from Presiding Officer Tar and myself shortly. And that will include two varieties of conditions that would be triggered in the event of a constructive approval. One are common conditions that apply universally to all projects of any type that the siting board reviews. And then there would be, you could think of them as technology-specific conditions, say for energy storage facilities, transmission and distribution projects, generation facilities. So those would be a predetermined group of conditions by technology. So there would be no discretion at that point. Whatever is on the list of the conditions, the common conditions, would be invoked in the event of the constructive approval. Did I get that right?
Yes, and the point is that the constructive approval would happen basically by operation of law. We have regulations that provide a process to get that out the door, but the board would not vote on those conditions. Therefore, there's no opportunity for the board to vote on project-specific conditions.
Okay, thank you. Any other, is there questions online? Yes. I can't read it though, can you?
Let's see. Yes, Lara Wall. Lara Wall, we'll move her to the panel.
So when you come on, please say your name and spell it if necessary. Thank you.
There she is.
Hi, can you hear me?
And thank you.
Hi. Okay. So, okay. It's a little vague when you say reasonable efforts, right? So will there be hard data on what you will consider reasonable efforts? Or is it just kind of up to the discretion of the board is my first question. My second question is, are you taking the applicant's word for reasonable effort to do? Or are you also going to be consulting with the municipalities of what was actually agreed upon? So most importantly, also, I wanted to say that I don't believe that it should be changed, the language from shall, which is stronger, to may. I think the community absolutely needs to be involved, as you are our public servants. So that is my comment of my two questions, but most importantly, yeah, what is reasonable efforts, and will you have hard data?
So I can just give you sort of my general view, and then the staff can elaborate. I mean, it is very common for the siting board to have reasonable efforts or things, determinations as to whether things are reasonable. A lot of balancing happens at the siting board, and so you take all factors, and that's why you have a broad range of people on the siting board to make a determination as to whether something was reasonable. Certainly, any party in the case will have an opportunity to argue that something was or was not reasonable and to present evidence along those lines. So do you want to add anything more?
So I think the last point that you made was important. Instead of hard data, there will be evidence that's presented during the siting board proceeding. And the siting board would consider that evidence. So it would not be just the applicant's assertion that they engaged in reasonable efforts, but we would look at meetings, number of meetings, types of meetings, what was discussed. If an applicant is not able to present information that there were actually any meetings, that would be a significant factor that the siting board would consider. So this is an adjudicatory proceeding. The siting board takes evidence and weighs that evidence.
Could there be an established set of metrics of what you will consider reasonable versus not reasonable, so that it's not just opinion?
Well, there will be specific requirements of how pre-filing requirements that applicants will be required to do prior to being able to file the application, and those are laid out in regulations
16.0, which we will hear
16.0.
about later on today.
Okay, thank you.
Thank you for your comments. Yes, Jessica.
Thanks. So my question was about,
you say
oh,
your
sorry,
name and-
Jessica Robertson from New Leaf Energy, and I'm a member of the commission.
She's Jessica Robinson from New Leaf Energy.
Thanks. My question was about the timing for a de novo adjudication that's been requested by a municipality. Understand your point about if they that if the de novo adjudication is starting from scratch, that they should have, that EFSB should have 12 months. My question is, if the local municipality has gotten partway through the process, at the time when they decide that they don't have the resources to complete it and then request the de novo adjudication, does the clock restart at 12 months, or is there some other amount of time if a certain amount of the proceeding has already taken place?
As the regulations are drafted now, I would say that the do you want me to? My name is Daniel Kelleher. They provide that the clock will restart and that the director will have 12 months in that situation. Ms. Evans?
So the local community has a limited or defined amount of time to determine whether or not to send it up to the board, to the director. So the community can only get that far into the application before they have to send it up. And is it 60 days? I can't remember off the top of my head. It is in the regulation. Therefore, I believe that Mr. Kelleher is correct that the 12 months would start when it comes up. However, the board would certainly be interested in absorbing whatever information already happened at the local level into its proceeding, and possibly could go quicker if a number of steps have already been taken at the local level, which we would of course prefer that there be some activity at the local level before it comes to us. But the way the provision about sending it up to the board is currently written, it could be that nothing's happened with the application at the local level when it is sent up to the director. And we want to make sure that there's enough time to take the procedural steps necessary with the local community in order to fully review and make a decision on that application.
Can I just, I'll just add to that briefly, that the regulations as they're drafted say that the local government is subject to that 60-day deadline, except if the applicant provides for permission. So I just wanted to clarify that. So they're not necessarily limited to that 60-day deadline. And I do understand your point that the actual amount of time that might be required by the director in a situation where the local government has done a partial review might make it possible for the director not to need as much time for the de novo adjudication.
Any other comments? Yes. Can you say your name, please? And
This is on. Oh, okay. Hi, Priya Gunbear, Conservation Law Foundation. It's GANDBHIR. Okay. Just for following up on that, when the local governments are issuing their orders, is the 60 days apply? Is that from the close of the hearing to the issuance of an order, or is there a timeline between the close of the hearing and the issuance of an order that local governments need to adhere to?
I'm not quite clear on the question because what starts a timeline is that an applicant files a consolidated local permit application with the local government. And then they have 60 days from that date of application to ask the director to conduct a de novo adjudication. And so in that situation, there's no hearing that necessarily takes place. So maybe you can specify which hearing you're referring to.
I guess so. I'm thinking, in my head, I'm like automatically comparing to a conservation commission hearing or a zoning hearing, and like for example, conservation commissions once the hearing of the application has been concluded, there's a timeline by which we have to issue our orders, or I think 60 days. It's been a long time since I've done zoning work, so I think 60 days is the rule for zoning boards. But I'm thinking of the de novo process as an appeal, essentially. So
I think what they're talking about here is a situation where the town gets an application and says, oh geez, we can't handle this, right? Like this is going to be we're a small town. We really need the siding board to do it instead. So when they get that application, they have 60 days to make that determination as to whether they're going to have the town issue the local permit and go through all the local town processes, or whether they're going to ask the siding board to do that. Am I right?
And then the siting board process would kick in at that point. Any hearing would happen at the siting board, not at the local Concom or the local at the local level.
And that's the same. I think there was a first bullet that said, like, if somebody objects,
So there's
goes to de novo.
There are two different paths that a local permit decision or application can get to the siting board. The first path is the local community makes the decision, local government makes this decision, and then the if someone is dissatisfied with that decision, and the decision could be even a constructive approval at the local level, but there's a final decision that's made. If someone's dissatisfied and they are substantially specifically affected by that decision, they can ask the siting board. It's not really an appeal, it's a fresh look, but that comes up to the director, and that's a 6-month process because the local community's already done all of their process. There's been hearings, there's been meetings, there's been a decision. The second process that Mr. Kelleher was talking about is a 12-month process, is if the local government gets an application, looks at it, says, as Secretary Shepard said, we cannot do this, and then sends it up to the board, and the board then initiates its process to review that application and make a decision on that application. And that's the piece we're saying would take 12 months because there had been no local process.
Thank you.
Any other questions from the public? Anyone?
I have a follow-up point on constructive
Please,
approvals.
please.
Thank you. So back to constructive approvals and the comments that were received about including project-specific conditions in a constructive approval. I assume that we tried to make this change because of a concern, the change to disallowing project-specific supplemental conditions in a constructive approval because of a concern about a lack of siting board deliberation in that context. Is that right?
I think also it's a constructive, it's supposed to just issue.
Right.
Right.
I just worry that by that point in time, right, you're approaching the 12-month mark or the 15-month mark. There's been a lot of work by everyone, right? There's been a lot of consultation, engagement, including with permitting agencies. who may have already recommended, if I am understanding the sequence of the process correctly, there may already be fairly detailed recommendations about permit conditions from those permitting agencies. And I'm just wondering if there's a way to not have it be so binary that you get this full detailed set of conditions or you get nothing at all and you just get the baseline standards when most, if not all of that work would have already been done by that point.
It is likely that we get to that point, you're right, after we've had our proceeding. First, like to say, the board staff intend not to get to this stage.
Right.
But we needed to have regulations because this is a provision of the act. It is likely that when the presiding officer makes the determination, it looks like this is not going to make it to a board meeting. There has been a full proceeding. There's been an evidentiary record. There's been briefing, and that whole record is existing. That's absolutely true. There's not a mechanism that we see to impose project-specific conditions in a consolidated permit situation because it happens without the board's deliberation. It happens by operation of law. That being said, it is staff's understanding that the applicant has provided all this record. We have a record at that point in time, and the applicant would need to build consistent with the record it was provided to us, provided to the board during the proceeding, which is consistent with how the board views the applicant's record now. The applicant must build consistent with the record that has been provided to the board.
Will that be a common condition?
I'll pass this on to Mr. Green, who is writing the common conditions right now.
That's a very wise idea. I think the answer to that is yes.
Thank you.
It is currently a provision of the current board decision that the applicant must build consistent with what they told the board, because we don't regurgitate the whole application back in one of our decisions right now. So that is a condition now, but we should consider putting that as a condition going forward.
Well, yeah, and I would say consistent not just with what the applicant told the board, but with the entire record.
With the record.
Right. Thank you.
Well, I don't see how you do that, frankly.
Okay, back to it.
Well, I'm just trying to think from a practical standpoint. There's been no agreement on these specific conditions. It's people have suggested them, but they're not something that has been approved by the board. So if you're an applicant, how are you going to figure out what's really required and what isn't? You don't have approved conditions. You have lots of people saying stuff in a hearing.
Well, I do wonder if the recommended permit conditions of the relevant permitting agency could be taken differently. I mean, if DEP, for example, recommends some sort of condition to, surrounding the wetlands buffer, for example, because you need that buffer to be consistent with the requirements of our state statute. Something happens, the project gets a constructive approval for any number of good reasons. If DEP had made that comment as a recommended permit condition as part of the record in the proceeding, I do think that should apply to the applicant. Otherwise, then, if there's an issue with the buffer down the road, I don't know how we enforce that if we say from the get-go it was never compliant with state law.
Let's think on this.
Okay.
It is a very good point.
It is a very good point. And the constructive approval regulations, I will say, have gone through multiple iterations trying to address that very concern. I think, though, that if the applicant says during the proceeding that I'm going to affect XYZ amount of wetlands, or they can't build it differently than that. They would need to build it according to that or come back to us under the project change provision. But I think devil's in the details on exactly how you enforce that. and we do need to think about that some more.
The point I would make is that the standard or common conditions, can address some of this, maybe not every detail of the proposal that might be made by other permitting agencies, which includes not only the state agencies, but also local officials. And oftentimes the recommended conditions are not necessarily aligned, so we have a difference of opinion, which the chair was alluding to in terms of open issues that we have on a record in a proceeding that wouldn't be decided in a constructive approval. But I think we can have a condition that tries to clarify where that boundary line is between what's been defined in the proceeding and perhaps even accepted or consented to by the applicant. There may be a way to sort of finesse this in how the conditions are worded. And that's part of what we'll be doing.
Thanks. Yeah, I wonder if even partially helpful, and you may already have this just as like common condition number one, but just a baseline requirement that the project comply with substantive requirements of state law, so that if their proposal does not, and our agency comments or conditions would have addressed that we have at least something on the record that the project need comply, even if there's a subsequent approval, we have a foothold to enforce state law if needed. A foothold to enforce state law if needed.
Complying with state laws and regulations is definitely on the list.
Condition number one, perhaps. One more comment about common conditions, which I know folks are working on. I do think another valuable common condition in response to one of the comments provided earlier about mitigation is important as well. I think we want to be encouraging applicants to engage with their community to mitigate impacts of their proposed project, even in a constructive approval type scenario. Thank you.
Do we have any more? Are there any more comments? So why don't we take one more comment and then take a break?
Janet Sinclair. Janet Sinclair is moving to the panel.
Yes, hi, I'm Janet Sinclair. I live in Shelburne Falls. I'm just wondering, I was just listening to, for example, a wetland setback. The state law, the DEP regulations for setbacks for wetlands are whatever, 200 feet from a river, 100 feet from a vegetative bordering wetlands, right, type of thing. But what if in the town they have a bylaw that says that there needs to be a 500-foot setback from a wetlands, and then the town tries to impose that condition during this process, but it's not the same as state law. What would you say about that?
So the regulations that are being developed by DOER are addressing town conditions and are still in development also on how the town condition would be included. I don't know if DOER has more detail on that right now.
Well, what I was really, I mean, I know there's going to be a different process that goes on here with DOER for these quote unquote small projects. And my understanding was this process here with EFSB was for these, large projects. So these larger projects will go through a different process, right? So I'm just wondering, like in your process, and something is a large project, that will come before you, and a town says, consults with you and says that this setback, the state setback isn't sufficient. like, how would this board handle that, do you think? Or that's my question. I think that's something that should be addressed, I guess, maybe in your, consideration here today.
Thank you.
Okay.
I think as an initial matter, the board is intending to reflect DWR's requirements for the local part of a permit, because many of these projects need, even the large projects need state permits and they need local permits.
But even like a 200 megawatt battery, that's clearly going to go to EFSB.
Probably also needs local permits, needs state permits and needs local permits. So they would need both. The siting board would issue both, but we would reflect and be consistent with DWR's regulations on the local part, the local permits that need to be issued. So we're working together to make sure that the requirements are consistent.
Okay, that's extremely helpful. Thank you.
Okay, why don't we take a break? A 10-minute break, and then we'll come back and we will start on 980 CMR 13.
You say that again? Say that again, please.
We're going to get started. Everybody's having a good time. All right, we're going to take up next Regulations 980. I'm on the record, yes. Thank you. We're going to take up next 980 CMR 13, and we're going to hear from Siting Board staff.
Thank you, Secretary Tepper. For the EFSB application section, which is what we're covering now, I will be speaking to that along with Presiding Officer Connor Tarr, who is at the podium. So we'll be handing this back and forth.
Sounds good.
So to dive right in, first of all, this may be familiar to those who've come to earlier sessions, but the 2024 Climate Act requires that we have applications for all of the clean energy infrastructure facilities that we review at the Siting Board. And that's not a radical statement, but it is a very important concept in that the board has not had applications for the vast majority, or excuse me, required application formats for the vast majority of applications that we've received over the past decades. So this is a really important step to standardize the information that's filed, to make sure it covers all of the necessary topics, and that we can make a determination that the information is sufficient to continue the proceeding and start the clock ticking. We talked about constructive approvals before, so that's the consequence of the clock reaching its endpoint and the board not having made a decision for whatever reason. So as this slide depicts, there are a few different application concepts to cover. One is that the EFSB has applications that address the jurisdictional projects that the board is responsible for administering, which includes the large clean energy infrastructure facilities under Section 69T. And that concept is known as a consolidated permit. The terminology can be a little imprecise here, and this is in the statute, so apologies for that. But a consolidated permit, as we use that term, means both consolidated state permits and consolidated local permits, which, as the General Counsel indicated before, the Siting Board issues. The board also has the ability to cover small clean transmission and distribution projects under Section 69U. That also would be an application topic. Again, that's a consolidated permit, all state and local permits. And finally, the small clean generation and storage facilities under 69V. This is an optional or an opt-in provision where the proponents can request the state permits under a, quote, consolidated state permit. So the board would be issuing, or at least asked to issue, the state permits, and local government would review the request for local permits. So it's a combination approach there. This all works in tandem with what DOER is developing in terms of the consolidated local permitting process under their regulatory aegis. And we're working very closely with DOER to try to have alignment of really all of the components, and there are many that overlap because, again, our authority does include the local permitting function under various scenarios. So this is a major theme right now in developing our regulations, of working extremely closely with DOER and their new siting and permitting staff, led by my colleague, Rick Collins, who's sitting over behind Presiding Officer Tarr. The DPU also has involvement in our applications process because applications will have fees, and the siting division, which is the staff to the board, it exists within the structure of the Department of Public Utilities, and the DPU handles the administrative functions of the siting division and the board itself. So the department will be handling the issuance of a regulation for the fees that accompany applications, and other such administrative matters. That's a pending topic that we have not yet issued a draft regulation for comment, but that is in process and hopefully will be seen in the very near future. Okay, next slide. This chart again is part of our familiar repertoire of information about the 2024 Climate Act. This tries and hopefully succeeds in clarifying which process covers which types of facilities. Again, not everything comes to the siting board. Some facilities will be reviewed at the local level, and the proponent will have the option to come to the EFSB for a consolidated state permit, but is not obligated to do so, in which case they could seek individual permits from state agencies like DEP, and so forth. So this chart has a lot of detail on it, but it does break it down in terms of generation, storage, and transmission, and the difference between large and small facilities, and importantly, which pre-filing process would apply under which circumstances, with the sort of orange color denoting that it's an EFSB pre-filing process, and the blue color indicating that the pre-filing would be governed by the DOER regulations, and we would not have a duplicative pre-filing process. So read the footnotes. They're also worth your time and attention. Next slide, please. Okay, this is a new graphic. I know this is a little busy. I'll try to give you a sort of understanding of this so you don't have to figure out which direction all of the arrows are pointing. But this is really a conceptual map of the EFSB consolidated permitting process. So at the center of this map, if you will, is the blue box, the very center, which is titled EFSB Consolidated State Permit Application. So this is the function where the board would be reviewing requests for all of the state permits that are needed for a facility. Again, it doesn't always apply, but frequently it will. The green box surrounding that state permit box reflects or represents the local permits that would be part of the board's function in the overall consolidated permitting program. And again, depending on which type of facility and whether the proponents have opted in for different types of reviews, it could be just a state permit. It could be both a state and local permit, but the board does not issue only local permits. That's one thing we do not do. So that would not, the local permit function is connected to the issuance of a state permit. So what we have at the top of this illustration or map are the standards that would sort of govern and feed into how the applications are developed. We have standards that DOER is working on, again, in coordination with the board, that affect local baseline standards. And when we talk about standards, we're talking about environmental, health, and safety requirements. These are references to state law, state regulations, which we were talking about before, and other provisions that have been established and are seen as necessary to make sure that, again, the public and the environment are being adequately protected. So the green box are the local standards. The blue box that feeds into the state permit area reflects, again, statewide or state standards from state agencies and the different CMR regulations. Below in the center, we have the common conditions. Again, these sort of break down between the local conditions, which DOER is primarily developing in consultation with the board, and the blue box being state permit common conditions. So these are the kinds of conditions that DEP, Fish and Game would typically be looking for in their decisions and opinions and so forth. So these again, govern, what needs to be included in the application and the content of them. Application forms, same general idea that DOER is leading the way on developing what they're calling a common application for local permitting. And I don't want to speak for DOER, but I think the intention that is fairly clear at this point is that instead of having 351 different flavors of local applications, DOER is working towards a consolidated common application that would apply statewide for the local permitting function. And that would feed into our process as well at the Siting Board. We would use that and develop and have already presented in our guidance documents the application contents that we're looking for to cover the EFSB's jurisdictional requirements. And we're also intending to fold in application forms that are used by other state agencies. So for example, if you're applying for or need a permit that's normally issued by DEP for whatever program, our application would reference using the prevailing DEP application or other state agency applications. So there's a lot of different components that get woven together in the applications that come to EFSB. Once the application is submitted, where does it go? We're, again, working with DOER to develop a new filing portal. The department has an e-filing system that's been around since the early aughts, late 90s, and it's showing its age, or at least it has been revamped, but it still is not quite finely tuned to the needs of a consolidated permitting program, which involves a lot of significant local participation and involvement. We're looking to create a slightly different type of filing portal where the folks who interact with the permitting process can upload documents directly, and this will be the kind of filing system that would support both the local permitting functions as well as state permitting at the EFSB. That's still at the early stages of development, but something that's a very important priority for this program. And again, that's a common undertaking of EFSB and DOER. Application fees, I mentioned that would obviously be a requirement of applications that are submitted to the board, and we're developing a fee proposal to govern the application submissions. The diagram here at the sort of lower left shows that there are three intended recipients of the funds that would be remitted through the application fee. The most basic function and purpose is to support the work of the Siting Division and our staff. Not all of our funding would be provided through a utility type assessment, which is the longstanding funding mechanism for most of the DPU and Siting staffing and administrative functions. So that's kind of job number one, if you will, of application fees. We have the Intervenor Support Grant Program, which you'll be hearing about a little later from my colleague Veena Damaraj. The statute also indicates that filing fees can help support that program. And then the third box, which is titled here PEA funding mechanism. This is a concept. This is not specifically called for by the statute, but the idea is that since EFSB would be receiving applications, they would not then be going to other state agencies or local agencies, and that they would not be receiving the normal application fees themselves, which are necessary and important for their staffing costs and other administrative fees. So we're hoping that there's space in this fee process to create a funding mechanism where some of the application fees can help be transferred to other state agencies or local agencies as well to support their participation in the siting process, which is specifically required under the Act. Okay, we can move on. Next slide, please. All right, I'm going to turn to Mr. Tarr.
Thank you, Director Green. So first, we're going to focus on the application completeness determination. This was focused on, and again, my name is Connor Tarr, presiding officer for the siting division. We're going to focus on the completeness determination that's made by the presiding officer, that's made within 30 days of the application being submitted. This would follow the pre-filing that the applicant has already done with state agencies as well as at the local level. So some significant points for an application completeness determination and some language that we made sure that we had included was substantial and material compliance with the informational requirements. There was a lot of discussion last time at the board meeting regarding substantive requirements versus informational requirements versus what level of requirements would we be looking for as part of a determination for completeness. So we have indicated that we are going to focus primarily on the informational requirements as part of the completeness determination. There would be additional opportunity for completeness regarding substantive matters as part of the process throughout, as far as becoming an intervener, asking questions, information requests, evidentiary hearings. There will be a number of opportunities to resolve any outstanding matters. We would hope that most of those matters are resolved as part of the pre-filing process, though, as far as pre-filing consultation with the agencies themselves, so that that isn't an issue. However, there is an opportunity for that worked in now. Additionally, we would like the applicant to identify any relevant state, local, or regional permits that would be required. There was some discussion earlier in the board meeting regarding common conditions, and as far as from the agencies themselves, it would be our hope that any kind of common conditions from the agency would be incorporated based on the permit that is being applied for. So there would be specific common conditions associated with each permit that's being requested from the agency, so that that can be worked in and be incorporated in as a common condition for any and all applications that would include that type of permit. I did want to clarify that from earlier. I was going to jump up, but figured I'd talk about it now. Additionally, as one of the comments earlier in the meeting as well, was identifying conflicts between standards. We would be requesting that the applicant identify the specific conflicts as far as what they're identified as, and potentially propose a resolution as part of the case. Now, that doesn't resolve any issues that would be taken up as part of a constructive approval. However, that would be a matter for the board to make that determination for how to resolve any differences regarding local permitting versus state permitting or state requirements. We can go to the next slide, please. Now, we did receive a number of comments on 13, and we did make a number of specific updates regarding those comments that we had received. The first generalized comment was regarding the flow of review for the opportunity for information. As indicated, the initial opportunity for information coming in will be through the pre-filing process. That'll be discussed further later. Then the application would come in, which would be evaluated on an informational basis. And this will all be detailed more specifically in guidance. So we're going to have a significant process developed in guidance so that an applicant would be aware of what they would be expected to include as part of the application process. So there will be a checklist for them to provide to the EFSB as part of that. So that'll be detailed more in guidance, more to come soon. Additionally, we also had received a number of comments and questions regarding the standards of other permitting agencies. We are intending to incorporate specific language into 13.0 that would incorporate specific language into the regulations regarding references to standards that would be governed by those agencies. So we did want to ensure this is primarily governed under 1307 on page, if you printed it out, page 12. Under 1307 for this baseline standards. So it ends up being referenced through guidance, through the baseline standards that are currently being developed, but that will reference the agency standards themselves. So those should be the ones governing moving forward. Next slide, please. Turning more to some specific requirements or some specific modifications that we made to 13.0 from the last time that we had appeared. There was a request to modify the definition of construction to include permitting activities on the site prior to the actual commencement of construction. So this would include boring and other types of field studies that would need to be conducted in order for any permit to be issued. So we did modify the language of the definition of construction under 1301 subsection 4. There was also discussion regarding the waiver of pre-filing. I know that we had a lengthy discussion regarding the concerns on the waiver of pre-filing requirements last time at the board meeting. This was resolved, or we believe that we've resolved this through 1303 subsection 1E2. If you want to go really deep into the regulations. This is now including language that we are going to require the applicant to include the description of the waiver as well as the determination from DPP decision as part of the pre-filing process. So there's a requirement for a decision to be made. So that would need to be included with the waiver as far as their decision on the waiver of those pre-filing requirements. Next, we're going to go to zoning exemptions. There was a number of comments that we had received and concerns, understandably, regarding our treatment and our decision regarding zoning exemptions as far as being included directly in the application. We are still requiring that as a separate petition under 40 subsection 3. That would be under the governance and decision of the presiding officer to determine if they would like to consolidate, which I would anticipate in most opportunities and cases that we would. Again, that's under section 1304. There was some other concerns that we had at the last board meeting, as well as a number of comments that we had received regarding the narrowing of the completeness determination, as I had mentioned earlier as part of my presentation. We did review the limits of the completeness determination. We did try and mitigate the current process and leave it as is, as there is a number of balancing opportunities that the presiding officer is required to make, as well as the board themselves. And we feel that the balancing process as it stands right now would be an effective way of balancing between, do we have enough information to move forward with the actual timeline, or do we need additional information before we would feel comfortable commencing the 15-month or 12-month process? Again, that is also under section 1309. There was also a number of comments that we received regarding whether or not all projects should include and be required to analyze every topic in guidance. I think there may have been some confusion regarding what guidance actually is and what guidance is meant to be. Guidance is not indicating every single topic that would be required from a project. It is every possible topic that could be considered by a project. So if there are topics and subsections that are not addressed by the project as they are inappropriate, that can be indicated with a simple NA as far as not applicable, and that would be resolved through the completeness determination process. Next slide, please. All right. Some other primary key updates that I would like to advise the board about. There were a number of definitions that that were originally included in 13.0 that are now have been moved to 1.0 as they are applicable to a number of other sections, and we felt that it would be appropriate to have it apply throughout. So there are a number of definitions that were removed from 13. Also through advice and other comments and suggestions, we had reorganized the section for 1303 so that now there would be organized into a general section, and then a T&D section, and then a generation and storage section, so that those are separate, so that it reads more linearly if you're an applicant, so that you're aware these are the common conditions that are common requirements that are applied to every case. These are the specific conditions that are, or specific requirements that are needed to be applied in a T&D facility application, and then these are the specific requirements if it would be a generation or storage facility. We also made some additional modifications to 1311 for the enforcement for the directors, so that there would now be the director would issue a draft ruling, there would be a comment period, and then a final ruling regarding enforcement. This would be specific to EFSB enforcement conditions. So this would not be pertaining to anything under the governance of a permitting agency or under the local authority. This would only be specific to EFSB conditions themselves. One final thing that's not on the slide, but I do want to point out and bring up that was alluded to by my colleague, is regarding the unexcused delay that the board had requested and wanted to have included. That has been added to 1306 for the procedures. We have made a specific requirement regarding unexcused delay, so this would apply anywhere throughout the process. Of essentially, a first unexcused delay would be deemed an unexcused delay by the presiding officer, and then any subsequent unexcused delay, meaning that there was no grant of an extension provided and no request made by the applicant, would potentially result in the application being deemed incomplete, which would reset the full timeline if necessary. So this would allow the board to have a full 12 or 15-month time period for review after that delay had been caused. So this is specifically crafted so that we would not have the expectation of any delays on the part of the applicant moving forward. There is also a cure that was included in that language as well. The cure would be to provide an update to the board regarding why that happened, how that will not happen in the future, as well as the response that was late at that time. And at this time, I'm going to take any questions that the board has, or Director Green.
Any questions from the board?
I have one on that new language about unnecessary delay in 1306. The last provision there indicates that the board may issue penalties to an applicant who violates an order of the board. I'm just trying to think through how that would play out here, because the preceding provisions all relate to actions by the presiding officer, not an action by the board. Can you talk a little bit more about that?
I believe that the purpose of that language was specifically so that if the board chose to impose sanctions of some type, some type of monetary penalty, they would have the option to do so.
But is that only if the applicant violated an order of the board, or if there were violations of timelines or orders by the presiding officer? Something like that.
I think that the language for order of the board may be a bit ambiguous in this sense. I think as the presiding officer acting on behalf of the board, as far as issuing an order regarding the delay or the implication of the unexcused delay, I'm going to refer to General Counsel Evans.
So that's an existing provision under General Laws 164, Section 69H. The board currently has authority to issue penalties, it would be the board that would need to issue the penalties. So there would be need to be a process in order to issue penalties.
Understood. May we only issue penalties in response to a violation of an order of the board, though? Or could we issue a penalty in response to a misuse of the process, a violation of a finding by the presiding officer, what have you?
The statute says an order of the board. So I think that would be an order of the board. So they would have to actually refer a matter up to the board to actually issue the penalty.
Okay.
I will say that provision's been there, I think, for 50 years, and the board has used it once.
Oh, we
So-
never want to be in any of this section. I'm just thinking of a worst case scenario where we have a real abuse or misuse of the process. The presiding officer has taken various actions to try to get things back on track. If the only recourse of the board, if it is really needed, is to issue an order and then a violation and a penalty of that order, or if we have the record of the presiding officer and we can take action on that basis.
I believe that the board would probably need to take that action, but we've not used it, so we've really not developed a real full process for that. I think the other remedy, right, to an unexcused delay, of course, is a denial. So that is another remedy that the board could use, but we try to respond to the board's questions from the last board meeting about concerns that an applicant could use the process, delay the process such that the applicant would end up with a constructive approval. And so we've provided a number of steps the presiding officer could take, but I think that there's also the additional step that the board could take by issuing penalties.
My guess is that for penalties, it's a due process issue that the board would need to do some process itself.
Right. I was trying to clarify whether that process is just a finding of the violation on the basis of a violation of the presiding officer's action versus we have to make an order as a board and then find a violation of that order. I agree with you that we need some process in any event. Okay, that makes sense. Thank you. Again, not something anyone's looking to turn to, but we do need to have teeth if we find real abuses of the process.
No other questions from the board? Okay. Are there any questions from anyone here or online?
Hello, Steve Long with the Nature Conservancy in Massachusetts. So I appreciate the mentions of site suitability in 13. And there were a few other places that mentioned environmental impacts. I don't have the exact reference here, but it's on page 13 of the printout. Apologies for not having the CMR reference. Page 5 of section of CMR 13. So, I'm just wondering, is there a reason not to tie site suitability in that list of environmental impacts? Sure.
Mr. Long, could you clarify your question? I'm looking at this language. I'm not exactly sure of the question.
Okay, so I'm looking, my apologies for not having the numeric reference here. I'm looking at 13.03 subsection I, and there's a list of environmental impacts. And there's site suitability is not listed in there. At least I didn't see it. So I'm wondering if there if there's a reason not to list it in there and have that cross-reference.
I believe this is under section 15, right? Site suitability. So site suitability would be referenced as part of H above that for the cumulative impact analysis and would be part of the cumulative impact analysis required under 1505 is my understanding.
So also site suitability does appear a little bit later on the next page, Mr. Long, under site selection and alternatives under 13.03 subsection 3 subsection A, and does reference site suitability scores
Okay.
in the site selection analysis to be provided by large generation storage and small generation storage requirements.
Great. I just want to be sure that everything's cross-referenced. So that's helpful to know. Thank you.
It's actually referenced also up above in
is.
transmission and distribution, the large and small transmission and distribution routes and site selection analysis. So it appears both for transmission and generation and storage does reference. It does appear for generation, storage, and transmission route and site type analyses do cross-reference site suitability scores in the regulations as they are currently drafted.
That's great. So from what I understand, you're saying site suitability is definitely included. It definitely helps determine where a facility would go. And I'm just trying to tie it to the environmental impact too. Not just the site selection, but once a site is selected, the avoidance, minimization, and mitigation. So I'm sure you have it covered. I just was looking at that list of environmental impacts and was curious why site suitability wasn't listed there. So,
Mr. Green, I can't answer that question, why it's not listed there. Also, maybe you could help with that.
I don't think it would be a problem to actually include it among the other different impact categories that are described in that subsection.
Okay.
It's consistent with the intent of looking very broadly at environmental impacts.
Sure.
and various criteria, and the site suitability criteria are certainly not only relevant, but obligatory for the board to consider in its decisions. That's part of the act. So including it here, to me, would be consistent and sort of a, helpful clarification of that point.
Thank you.
Any other comments or questions? Anybody online? Okay, great. Let's move on. Maybe we actually should take our lunch break. Okay, let's do that.
Make an announcement.
All right, we're going to take a lunch break now from 12:50 to 1:50.
Give us 8 extra minutes. Thank you.
I know that. I was obsessed with doing this piece and then.
Yeah, pre-filing. That's a quick done. Very good.
Is that it?
Hello, this is the interpreter speaking. Can you guys hear me? Can you guys hear me?
We'll be going back on the record shortly.
Okay. They're working on some houses around here, and I think they cut one of the lines, so I'm using an alternate internet. I was just wondering if you guys could see me and I could hear you.
We can see you and hear you, but seeing is
Awesome.
the most important thing since
Yes.
you're doing the ASL.
Great, thank you.
She'll be back probably within the hour. So in the meantime, we will carry on. So the next topic we're going to cover is pre-filing engagement. I believe Hearing Officer Sharkey and Ms. Dharmaraj.
Next slide, please. Sorry, Alan. I know that the pre-filing engagement has been a very popular topic, both in the stakeholder sessions.
Rồi như vậy thì tôi biết là trước khi nộp hồ sơ thì
It's a wonderful and a watershed opportunity for the siting board to implement in regulations the outreach provisions, because we have been reviewing outreach. Okay. We have been reviewing the outreach activities of various projects. Okay. Is that better? I don't think I can get it much closer. Okay, we have been reviewing the outreach activities for various projects in individual cases. And so to a certain degree, we have established parameters of what we'd like to see in the outreach activities, and in terms of specific interactions with the communities in designing projects. However, at this point, by doing it in the regulations, we will have clearly established expectations, and they will be consistent across all the different types of facilities that come for approval before the board. We have made changes from what was presented initially in the stakeholder process and in some of the versions of the draft regs that people may have seen before now. Next slide, please. I don't think there's anything particularly new in terms of the provisions that are listed on this slide. We're establishing the regulations so that projects come to us without the need for further revision that might be required because of changes in projects design the communities have sought, or agencies may have wanted to see based on the permit applications that have been filed by an applicant. The requirements still require the applicant to consult with key stakeholders, the MEPA office, and permitting agencies, and to hold at least 2 public meetings with the communities, using multiple channels of outreach, and to create a project web page now that that seems to be a universal way to access the plans for a project and to determine the path that a project is taking as it moves towards its application to the siting board. However, one change that has occurred since the stakeholders meeting and since some of the draft regulations were circulated is that we have removed all the timing requirements without having a defined period in which steps under the pre-filing regulations must be taken. For example, when the initial project outreach, open houses with the communities must occur, and when steps need to be completed. Instead, we're trying to provide flexibility to applicants to accomplish all the steps required to do a robust project outreach process without necessarily imposing deadlines on when each individual steps might need to occur. I think that better reflects the very dynamic nature of a project development, as well as provides better flexibility in terms of the ongoing interactions between the community and the permitting agencies in interacting at various stages of project development. So in addition to removing the timing requirements that were in the initial proposals, we've also tried to do more in terms of specifying the activities that they need to take with regard to the permitting agencies, because we're trying to better integrate the permitting process for all the different environmental agencies and local agencies with the steps that need to be undertaken as we move to the adjudicatory process for a project. Hopefully the changes that we've made provide that type of flexibility, but I anticipate that we will continue to receive comments on changes that might need to be made. One thing that has changed within this process has been changes in the language of the draft regulations. For example, definitions were consolidated across the different sets of regulations and have mainly been placed in the initial regulations so that there's a consistent definition of something such as an application across the board. However, we have still retained certain definitions within the Section 16 regulations and refined those that are particular to the pre-filing outreach process. For example, the definition of a DPP opinion. There have been changes in the definition and changes in the elements of the completion checklist. There have been changes, refinements in the definition of community and in the definition of key stakeholders. In response to comments that were offered by different members of the public and different interagency discussions. I think we're going to continue to face challenges regarding providing additional flexibility in reviewing the steps of the outreach process. In particular, the integration with permitting by other agencies. I know that the requirements associated with consultations with other permitting agencies were not a strong emphasis in the initial part of the process. But as we have worked through the framework that the siting board is going to develop for reviewing these different types of applications, I expect that that will continue to evolve and that we will continue to get more comments throughout this process. The range of the focus of the comments that we've received about the process have varied from comments that given that MIPA was no longer involved in the process, why do we continue to involve MIPA or some of the other agencies? 2 questions about could DPP and OEJE have certain office hours for when people could come in and arrange for appointments? I think the changes that we've made reflect the really dynamic nature of the process, and we did not want to burden the regulations with very stringent requirements that would be unnecessary, perhaps, in a variety of proposed applications that we face for different types of projects. This has been an important step forward for the Siting Board, and it's an important step forward in terms of ensuring that the projects are vetted and are in the best possible shape before an application is filed with the Siting Board. I believe it reflects a lot of the best practices that are already in use in the industry, although maybe not universally, and that it will greatly help us in terms of ensuring that we can review projects on an expedited basis. Next slide. Oh, I'm sorry. Can you go back one to 1603? Thank you. So one of the concerns that people really expressed were with regard to the provision for a waiver. And I think that people were concerned that the waiver could potentially be an option that would allow people to almost completely opt out of the process. And that is not, in fact, the intent with establishing a waiver option. Having a waiver will allow the outreach steps that people have undertaken, but which may not have strictly conformed perhaps to timing requirements, but still represent a robust outreach process to proceed. And we have required the waivers requests and the DPP opinion on those waivers to be published on the project websites and be available to the public to eliminate concerns that people expressed that there might be some less transparent reason for asking for a waiver. Next page, please. So if you can see in the second column, there are a number of comments that we have received with regard to everything from questions about site suitability, the use of the CIA tool, when alternatives analysis are needed to be provided as part of the information provided for an upcoming project. We've adjusted language to address that. We've changed language with regard to maintaining information on meetings with key stakeholders, with agencies and with community to include more information so that's more accessible to the public and is particularly could be helpful for people who are unable to be available at the time of open houses, but want to maintain their oversight of a project and determine what their impacts might be that they're concerned about. We've adjusted requirements on the project webpage so that people could understand that they could receive frequent updates, at least on a quarterly basis of the information, but also opt out of receiving such information if they're not interested. We received a lot of concerns about what the duration of the public comment would be and what are the what the timing should be that would be acceptable to DPP, particularly if the original deadlines that were included in the straw proposals were retained. What we've tried to do is basically allow the pre-filing comment period to begin when the first public comment meeting is announced, and to continue to allow the process to proceed until they filed their notice of intent to file an application with the siting board. Next slide, please. Again, there have been concerns regarding the timing of the DPP process, how that fits within the timing of the pre-filing notice. We've updated the draft regulation that was originally published so that applicants who are having difficulty with certain deadlines potentially, or meeting certain steps as part of their outreach program, have more flexibility and meet with DPP and determine whether there are any identified difficulties in meeting the deadlines to file their pre-filing notice in their application. The one concern, again, in terms of timing, was when should they meet with DPP and OEJE, which kicks off the pre-filing outreach process. And for the purposes of the regulations, that initial meeting with DPP and OEJE essentially establishes the start of the outreach process. However, that does not necessarily mean that they cannot have perhaps already initiated their outreach process with the community. And again, the timing of the steps is less important from the perspective of DPP than the robustness of the outreach that has been undertaken. One concern in terms of providing information on who's key stakeholders and should be, and other project details that need to be provided to the public as part of the outreach, are going to be things that will be discussed most likely at the initial meeting with DPP and OEJE. In addition to most likely being a topic of conversation with the permitting agencies when they meet with the permitting agencies. On the next slide, we've made further adjustments in language to clarify the information that needs to be presented for the initial meeting and which provide more flexibility to applicants on information that are provided in subsequent meetings with DPP and OEJE and with the agencies. In 16061, we've made further changes which would allow the applicant to present copies of the draft permit applications and hopefully what they believe the draft permits will be, complete with conditions that the agency might likely impose as a matter of practice on a particular type of permit. However, they provide those as available so that if they're not available necessarily, for example, by the time they have a second meeting with DPP and OEJE, that they would continue to update the agencies, DPP and OEJE, as the project development advances and their permitting information becomes better defined. There were concerns expressed regarding the need for all projects to do an alternative analysis. There's been clarification in the regulations that generation and storage projects provide information on the site selection process for a proposed project. But the alternatives analysis, particularly as it's currently used by the siting board in analysis of transmission projects, will continue to be required under the regulation. There were a lot of suggestions received regarding the type of information that should be provided at the introductory meetings. So we've tried to provide an initial set of information which applicants should provide so that there could be meaningful discussion at its initial meeting with DPP and OEJE. And includes key information that the public will need to see regarding project contact information, project-specific issues, because those vary for every individual project that's filed with the siting board, and also ensures that translation and interpretation are available for public meetings with the community and on request with meetings with key stakeholders. There's a language access plan, which the board has in effect, which provides information to applicants on what the language access requirements are for meetings. Project web pages was a particularly fertile area for comment, both in the stakeholder process and in the draft regulation. One of the benefits of the project web pages is they can continually update information as it becomes available during the pre-filing outreach period. So therefore, given the dynamic nature of project development, people can check in to see how things are advanced and have the most current information available on the project website. We've also defined in 1609 requirements that are that should be provided on the project website, including location maps, which identify project components and include key landmarks and natural features within 1 mile of the project boundary. Frequently, when people review applications that have been filed with the siting board for a project, their first question is, how close is this to my house? What is this going to look like? By providing information on location on the project website, it will be much easier for people to assess impacts and determine how important those impacts may be to them. They're also going to be able to file the information regarding the status, pre-filing status checklist, which is a way of reviewing elements of the outreach requirements that have, as they have advanced throughout the process before the notice of intent to file with the siting board. That information will all be available on the webpage. There were questions about who should receive the pre-filing notice, because that would be essentially an important step just before the application is filed. We've updated the regulation to reflect that the notice should be provided to DPP, to the local municipalities, and to agencies, people who are on the project email distribution lists, and relevant key stakeholders. That way, people can assess the likelihood of the near-term filing of the application. One additional change with regard to the pre-filing notice is that local agencies and state permitting agencies should be able to review and provide recommendation on draft permit applications to DPP. This is truly a critical part of the process because A, it allows us to assess, or it allows DPP, sorry, to assess if there are any continuing issues reflected with regard to the outreach process, identify any potential problems in the dialogue between important community members and the agencies and the applicant. Since DPP's role in part is to facilitate the development of a better project through oversight of the pre-filing outreach requirements. And then finally, the pre-filing notice. We've updated some information with regard to the DPP opinion. There was concerns about the need for the pre-filing engagement checklist and the level of information that would come in and why it was being used. Was it just being used as an administrative way to ensure that different obligations were being met? But in fact, it's also essentially a notice that, in particular, the local government and the state permitting agencies would want to review to ensure that they are taking advantage of their opportunity to let DPP know of any particular concerns they have with regard to a project. DP is then serving the role of integrating all the information it receives from the agencies, regarding the consultation, regarding additional steps which the agencies may wish to be undertaken before they finalize the advancement of an individual permit. And those different elements will be integrated into the opinion that DPP will provide to the board. We're hoping that this will be a very important step in terms of integrating the permitting process at both the local, regional, and the state level. In evaluating the development of the project design that is ultimately presented in the application to the siting board. Does anyone have any questions?
I have a question. Thank you very much for the comprehensive overview. I just want to say that I think that these proposed regulations really do a great job of balancing transparency, getting information up front, and allowing flexibility. So I think it really balances a number of the competing priorities that sometimes are in tension with one another. I just was hoping to go back to section 16.04, subsection 1A1 and 1A2, which I think is on slide 37. Yes, right here. So could you just say a bit more about how an applicant knows whether they are preparing the site suitability criteria or the cumulative impact analysis, and how section 16 is reflective of this?
I think what we were doing in this was we were acknowledging that it's not applicable across the board for all applications. I think the true guidance on suitability criteria and the CIA will be forthcoming. I look forward to reading it myself. But there was a concern that by including it in the original language that it would apply across the board for all facilities subject to board jurisdiction.
Excellent. Thank you so much.
Since that page is up, if I can ask a question. 16041G4. This is the timeline for keeping the comment period open. Have you all done like a Gantt chart or something on the timing of this? It makes me nervous. I'm trying to understand first public meeting, second public meeting, 2 weeks, and squeezing it in to a very quick timeline.
Well, I think the very quick timeline that was talked about, it was trying to deal with perhaps the most extreme end of facilities that might be coming in for a proposal where there could be very simple projects that would come in and would still be able to operate on that very expedited process. I would not expect that the wide majority of projects would be able to. In addition, I think one of the things that we're going to be dealing with, particularly with projects, frankly, that are already under development, but have not yet filed and will not expect to file until the new regulations will be in existence. There were, I think, a lot of concerns that people raised because they've undertaken perhaps as much as 3 years of outreach prior to this, and they were concerned about, if we've already taken all these steps, do these steps still count as being part of a robust outreach process, and we being penalized by the fact that we've gone out and started this process before we necessarily may have been required to under the regulations. So that was why we're trying to provide that level of flexibility in changing the language.
So to be clear, I agree. I think having the 2 weeks after the second hearing is really important so that folks can really understand, be reflective, offer constructive comments. When I think about the overarching goal of this process is to provide a predictable, but also, quite frankly, speedier process to approving or reviewing projects. I'm just wondering, with that 2 weeks in a maybe 90-day process, when do you think in that 60 to 90-day process do you think that second hearing can happen? I'm worried about a first hearing happening on a Tuesday and a second hearing happening on a Thursday so that it kind of speeds it all up. I'm just trying to think of the whole calendar.
Thank you, Commissioner. The regulations currently, because there is no timing specified in the regulation as to when public comment meetings can happen, it is possible that an applicant decides to have 2 public meetings, one after the other, without a lot of gap between them. I like that you brought up this question, and maybe we need to add a little bit of more of clarification, saying that we need a minimum of X number of days as a public comment period. For most projects, I would think that the first public comment meeting happens after the applicant has met all of the key stakeholders. That's what we are requiring as a part of the regulation. And that the second meeting happens once the applicant has considered all the feedback that they have received from the first meeting before they have the second meeting. So ideally, there should be a little bit of a gap between both of them. But because we're not specifying a time or duration, I think it makes sense to clarify this further and maybe suggest a number of weeks that the public comment period should remain open from the start of the first meeting to the end of the second meeting and 2 weeks after. So that's something that we can include.
So to be clear, I'm not offering that as an amendment today, but I think it is something, as you're taking public comment on the regulations once they've been published in the register, that is something that we can explore. But that as you're exploring how that works out, do it with a calendar so that we really understand the implications to projects and to stakeholders.
Thank you, Commissioner.
On 1610 sub 4, slide 38. This is probably for Ms. Sharkey. Is there a view on whether local government and state permitting agencies should be sharing their assessment of the applicant's pre-filing consultation with the applicant, or only providing that to the DPP? Part of my question embedded here is a question about what the DPP opinion will contain. I'm not sure if it's kind of a compilation of the information that DPP receives, or if it's more of an evaluation of that information. So if there's a world in which an agency could provide something to the DPP and we say, they didn't applicant didn't perform a sufficient study of some sort of wetlands delineation in DEP world. Is there a world in which DPP may disagree and may issue an opinion that says something different, such that there would be a desire to not have two different types of evaluations and pieces of information going back to the applicant? I think in a world in which we're trying to speed everything up, it behooves everyone that if we see an issue, we tell the applicant about it as soon as possible. But if that's still under evaluation by DPP, I wouldn't want to do that prematurely.
I think our expectation would be that the agencies are kind of on an ongoing basis communicating with the applicant. And so that specific concerns that they might have about, for example, we need to have a noise study completed. We are concerned about the sufficiency of what studies may have already been initiated. That the applicant clearly would have those communications with the agencies, but that the agencies would also inform DPP so that DPP is aware of the concerns that an agency has. The DPP is not going to try and make an independent technical analysis of the work that an agency such as DEP is undertaking with regard to a specific permit. I think not that we are necessarily mirroring the process, but it might be similar to the requirements that the MEPA process had, which was to try and receive comments from the different agencies who were important to the permitting of a project, to have an assessment from those agencies of what the pluses and minuses of the project is, to what extent those concerns could be addressed, and the timing in which they might be able to complete that review. I'm sorry. Okay. And certainly I did not foresee a situation in which an applicant would be unaware of a concern. But certainly, I guess my expectation would be if an agency is sending their opinion to DPP, that the agency, even if they have otherwise had discussions with the agency, that they might provide a copy of that letter to the applicant so the applicant is aware of the information that's being submitted by the different agencies to DPP. Does that answer your question?
It does. Thank you.
All right, any more comments or questions from the board? All right, let's go to the room or on Zoom.
Mr. DiChiara, we're moving you to the panel.
There you go. Can you hear me now?
We can.
Great. Well, thank you for the opportunity. I just have a brief comment. So I'm Michael DeChiara. I'm from the town of Shutesbury in Western Mass. I am on the planning board and I'm chair of the Energy and Climate Action Committee and have been actively following and participating in this process. So just a general comment. First, I just want to thank, Andy and Wayne and the other EFSB staff. I think as far as I can tell, the process has been they've been open and responsive. I don't think anyone ever gets what they want, but I think the back and forth has been really genuine, and I'm appreciating that. I think the comment I would have, and I'll definitely, as things evolve, continue to do specific comments, but the general one, I guess I want to applaud EFSB for adopting the paradigm that a really robust pre-filing and engagement process is important. And ultimately, as someone said earlier, I can't remember if it was now or earlier in the day, that will facilitate better deployment. So if there's accountability, transparency, information, engagement on the front end, by the time it gets to the actual formal application, one would assume that the messy bumps in the road that usually prolong processes will be in the rearview mirror and things can go forward. So just, I think EFSB sort of spending the time to figure out how this should work well from a municipal perspective, a community perspective, the state perspective on the front end, and holding the applicant to a high bar of engagement and information sharing, I think is really vital for the ultimate goal of moving things forward smoothly. So wanted to appreciate that.
Well, thank you so much for your comments and for your continued engagement in this area. You always have thoughtful comments and appreciate that.
You're welcome.
Laura Wall is in the panel. We'll move her now.
Hi, I can't stay for the full meeting, and I don't know when there will be time to say this, so I wanted to make sure that this was said. I want to say that for the Holyoke meeting that the Siting Board hosted at the last hearing that was not recorded, there was countless people from the community who showed up, and their biggest concern was about our forests. And even though I've seen many changes here being made that kind of make it look like there's been a lot of community engagement and going back and forth, I want to make sure that, I guess I want to ask the question. I know for a fact that of the 300 comments submitted, over half of them were people from towns who are in active lawsuits with developers who are placing these projects, who are citing these projects in places where it is not commercial, industrial, or built environment. Out of the entire country, we are the only state who seems to be destroying our forests. And, you know, my question is were any of those comments taken into consideration and implemented into actual changes? Because it doesn't seem like any of our, you know, countless volunteer hours of going to these meetings and hearings and making comments have actually been resulting in any changes that I see today. It seems like you've made a lot of changes in terms of filing applications, but I don't see anything in terms of actually changing it so that our zones actually stand for something. You know, in a residential zone, we're not supposed to have these industrial projects. In farm zones, in forest zones, we have zones for a reason. And I don't see any changes that have been made from the countless people who have been coming to these meetings advocating for forest protections. And I want to know, is any of that going to be addressed today? And I'm glad this is being recorded. Thank you for answering my question. Please answer it.
Well, thank you so much for asking the question. I think the answer to your question is yes. We've put a lot of emphasis on the site suitability piece of this. So I'll let more people who understand it better than I do, but we're not talking about that today. So that's probably why you're not hearing what you're looking for, but it will be part of the process. So maybe somebody else can talk. Maybe our Undersecretary of Energy, Mike Judge, can provide us with some information on site suitability that I think will answer your question.
Thank you.
Yeah, so the site suitability guidance is required to be established by EEA, and there is a document. It is going through sort of the final stages of review. It will be out potentially as soon as the end of this week, but very, very soon. And that document it doesn't apply to all facilities. I just want to be clear about that, but it does apply to many facilities, and particularly most small generation or most generation and battery storage facilities would be subject to the site suitability criteria. And so that will have a scoring framework, and sites will be evaluated based on their impact to different types, based on different types of environmental and social impacts. So there's more details to come on that, but it is tied into the process that both the board is going to use to review applications, but also municipalities, and there will be consequences for
But
having.
my question, I'm sorry to interrupt, but my question is that, of course, I've been reading these documents per nauseum. I understand about the scoring that you have assigned to all of these things, but my question is more, have our comments actually resulted in change of your, policy moving forward? Have any changes been made based on the insane amount of feedback you've been getting from people who live in this state, not from these shareholders that are developers, but from actual people who have been writing to you and going to these hearings and speaking? Have any changes been made to that structure, to your citing process?
I would say yes. I mean, we review all the comments that come in. We try to make changes accordingly.
In terms of forest protections, though?
Yeah, there will be some details coming out. I mean, the site suitability guidance document that was the last version that was released, I think, went out around the same time the board had its meeting several months ago. It has changed considerably since then. So I would urge you to take a look at that once that becomes publicly available. Hopefully in the coming days and weeks. So
thank you all.
Any other comments? Okay. Let's move on. Talk about cumulative impact. Yeah. So we're going to have a brief update on the cumulative impacts analysis.
I'll kick it off. So I think, as everybody is aware from reading the tentative decision, or at least looking at some of it, as well as the package that we have today, we have not issued a draft regulation on cumulative impact analysis. There is a section that is reserved for cumulative impact analysis, 980 CMR 15, I believe, 15.00. And so this has been an ongoing work. I think we got some very good feedback at our board meeting late July that I think folks were, in general, I'll characterize it, that some found it a little bit dense in terms of the information and the complexity. And we heard that and have been considering how to make it perhaps a little more straightforward and simple, working with the Office of Environmental Justice and Equity. And I'm pointing over to my colleague, Undersecretary Maria Belen-Power, who perhaps would like to say a few words about where we are right now on the whole undertaking.
Sure. Can you hear me? Yeah, thank you, Andy. So we have been working on the guidelines for cumulative impact analysis. And like it was mentioned, it's going to come out soon, hopefully similar to the site suitability within. Sorry, is this better? So it's coming out soon, along with the site suitability draft. We have had several engagement meetings and processes, one-on-one, as well as group meetings for the past several months. And we have been sort of refining what we will put, what is in the draft. We are trying to strike the balance between sort of a step-by-step clear guidance, as well as allowing for flexibility, because every project will be different. And so that we are also finalizing a tool which will hopefully make it even easier to use and to do the analysis for cumulative impact. And happy to answer any questions if there are any.
One thing perhaps we could also just mention is that mapping is part of what goes into a cumulative impact analysis to try and identify what the statute refers to as burdened areas, We presented some information collectively in our last few meetings. And I don't want to steal your thunder under Secretary Power, but we are making progress on that.
Yeah, definitely. So this is something new, right? Massachusetts has never done this before in terms of cumulative impact for the siting of energy infrastructure. So we are developing this tool that will come out soon, ideally within the next week. I know I keep saying that, but it is, we are very close to having a model that we can put out there for comment, and that will be easy to use. This tool will be online, and project proponents and communities as well will be able to go and click on their community or on their project and see where they land. So yes, the tool will be coming out as well as the draft guidelines.
And in terms of just, additional steps to present the refined cumulative impact analysis and the tools and sort of how this all integrates and to get feedback, we are planning on having more public engagement. So today is certainly not the end of the process at all. It's not even really the beginning, since the proposal is yet to be seen. And we're talking about having a webinar or some other type of informational presentation with questions and comments that would be available for the public to provide, and that would perhaps be in the early part of October. I think that was the timing that we're looking at right now. So not too far off in the future. We hope this will, again, respond to some of the concerns that were expressed in July about the level of complexity. There were some bewildered looks in the audience as we were presenting our slides, and we noticed that. So we're trying to make this, again, more straightforward, and for applicants, a set of requirements that can be acted on with clarity and clear understanding of what the objective is, and to have that serve the public good and the purpose that was intended in the statute.
If I could just add to that, just to place it in context with the rulemaking process. So the intent is to have this public process happen before we propose the formal before we propose the regulations, so folks can see how this works and ask questions and make comments, the way we've done an informal process along with the other regulations where we presented them and allowed impact and allowed comment and back and forth before we actually propose a formal regulation for the formal regulation process.
Have we done enough on the site suitability, or are we going to say something about that? I think we're okay. Okay. So let's move on to intervener fees, intervener support and fees.
Yes. So we talked a little bit about that during the application, consolidated application process in 13.0, and our fee regulation in partnership with DPU is still in development. We have sort of more of the ingredients that we need to calculate fees that will hopefully produce the amount of revenues that we need to support our administrative costs, to help fund the intervener grant support program, as well as have funding to, in effect, defray some of the expenses that our sister permitting agencies will be incurring, but no longer receiving their own application fees, which is part of our formula right now. As some may have noticed on our website for the rulemaking, there's also a link, I believe, to the Greener U management consultant study that was also required in the act, that was intended to try and estimate, what the workload will be on the siting board with this new process in place, how many cases, what types of cases, and what levels of staffing and funding would be needed to support all of that work. So that report has been completed. It's been filed with the legislature as required, and it is pointing towards a significant uptick, no surprise, in the number of cases, probably double or triple the number of cases in just a few years. So we are definitely going to be needing to enhance our resource base to keep to the deadlines and not have constructive approvals become the outcome of our proceedings, which we are really trying to avoid, as mentioned before. So, so knowing the numbers of cases, that sort of gives us one of the key mathematical components of what should the fee be based on the estimated number of cases to come up with a budget that we're projecting. And that also is in the Greener U report for what the siting board and division will require in the future. One thing we've learned in sort of looking at our fee development is that we haven't changed our fees in a really long time. The basic application fee for a transmission line, a generation facility, LNG storage, and we are, by the way, creating the fees in this process for non-clean energy too. It's the whole fee structure. Those basic fees have not changed since 1990. So the fees that were set at that time in statute at $75,000, if you did nothing but adjust for inflation, that would be about $150,000 now, give or take. So I'm not saying that that's going to be the proposed fee. I'm just saying that's the effect of inflation based on the passage of time since 1990. Fees for other types of facilities and applications like certificates of environmental impact, those haven't changed since 1973. So I don't even want to do the compounding math there to tell you what that would cost now, but it's more. So we're trying to update the fees to, again, reflect the need, not just do an abstract inflation adjustment, and to try to pin down, the assumptions for how much revenue comes in through utility assessments and other sources of funding. So we'll be putting out, again, with DPU at the lead here, a proposed regulation that creates a new fee structure that hopefully does all these wonderful things that we need to do to support the new program. I think that's.
Any questions on that? Okay, why don't we take a break? It is 3:05 right now. Why don't we come back in 15 minutes? Okay, thank you.